All right, so short lecture on the topic of due process of law. Last week we did a short lecture on judicial review and what that meant and how it made the Supreme Court, the judicial branch, a really equal branch of government. Today's topic is another related to the Bill of Rights, and that's due process of law. So we have three main parts to the lecture today, and the first one is just basically what is it, right? We want to start off with an understanding of what it is. So due process is essentially an idea, right? Due process of law is an idea. And, we can trace it back to the Magna Carta all the way back in like the 1200s, where the nobles of England put restrictions on the king and what he was allowed to do. Okay, that's one of those ideas that we borrowed, right? And we said we liked that idea, and so we put it into the Constitution. Specifically, we put it into the Bill of Rights. In the Fifth Amendment, you will see the phrase due process of law. And what it means is essentially that the government cannot take away someone's life, liberty, or property without fair legal procedures. I'll say that one again. Due process is the idea that government cannot take away someone's life, liberty, or property without following fair legal procedures. It does not mean the government can't take away life, liberty, or property. Right? The government can. The government can execute people. The government can throw people in jail. The government can take people's property. But they have to follow certain rules and protect certain rights if they're going to do that. Which then brings us to kind of the meat of this short lecture, which is, okay, well, what are those rights? What are the rights and the rules that the government has to follow? And so we're going to look at kind of throughout the criminal justice system, what are some of the due process rights? And this is not, every due process right, but it's some of the main ones that are in the Constitution that maybe you might read about in the news or something like that. And so starting with an arrest, right? From the moment someone is arrested, they have due process rights. So during an arrest, suspects must be informed of their rights. And I'm confident that from watching TV shows or movies with cops and things like that, you guys are familiar with this, right? What are some of the things that a police officer would say to someone when they're being arrested? Right to, yeah. Mm-hmm. Right. Yeah. You have the right to remain silent, right? You have the right to an attorney. Yeah. So, and that's called the Miranda warning. So basically, right off the bat, if somebody's getting arrested, the police are going to read them their rights. They're going to read them the Miranda warning. Okay. And so again, it's like right off the bat. Okay, and that actually, you don't have to write this in the lecture notes, but that comes from the um, a Supreme Court case called Miranda v. Arizona, where a suspect had been interrogated by the police and had not been informed of his rights, and the Supreme Court came back and said, "Hey, police, you can't do that. You have to tell them what their rights are." Okay. And so, police will read it right off the bat because anything that is said before the Miranda warning is considered inadmissible evidence. So again, right off the bat, suspects have due process rights, and they're told what they are. Now, before a trial, right, so somebody gets arrested and they're awaiting a trial, they have due process rights. So one of them, we just looked at some Supreme Court cases involving search and seizure, right? One of them is that even if they're awaiting trial, they still are protected against unreasonable search and seizure. And that word unreasonable is important, right? Because if you just say they're protected against search and seizure, no, they're protected against unreasonable search and seizure. Meaning that just because somebody got arrested, it doesn't mean the police can go ransack their house. Like, they still have to follow certain rules, maybe get a warrant, things like that. Also, before a trial, suspects must be informed of the charges against them. They have to be brought before a judge and informed of the charges against them. This has a fancy Latin name called habeas corpus. Habeas, H-A-B-E-U-S. Corpus, C-O-R-P-U-S. Habeas corpus. And that's basically, saying you can't arrest someone, throw them in jail, and then, just forget about them, right? You have to charge them with a crime in front of a judge, and if you can't do that, you got to let them go. During a trial, there are due process rights. Suspects have the right to a fair, speedy, and public trial. Fair, speedy, and public trial. This picture is a good example of a public trial. Why is it so important that it be public? Yeah, right. That it's open, right? That there's nothing being hidden. There's actually a really interesting Netflix movie that came out recently on the trial of the Chicago Seven back in the 1968 Democratic National Convention. These people were arrested, protesters, and the judge acted incredibly unfairly in the case, but we know about it because it was public, right? The media was allowed to write about it and people were allowed to be in the courtroom. So that public piece is really important. Okay. In most cases, suspects have the right to a trial by jury, right? They have a right to a jury trial. So it's not just the judge deciding It's not the lawyers deciding, it's a jury of your peers, right? Just regular people from society. Another important right is that you don't have to testify against yourself, or the Constitution calls it, right, protection against self-incrimination. But that basically means that you don't have to testify against yourself. You don't have to take the stand if you're on trial. You can. You are allowed to, but you don't have to. Yeah, absolutely. And in fact, there's a really interesting lecture from, I think it's from a law professor from Regent University down in Virginia Beach, where he talks about why even if you're innocent, because people always say, well, if you're not guilty, then why wouldn't you take the stand? You just make yourself look guilty. He points out that even if you're innocent, it's probably in your best interest not to take the stand, because you got to remember the prosecutor is a trained lawyer who believes you're guilty. And so if you take the stand in your own defense, it's a risk. Yes, it gives your lawyer a chance to ask you questions, but it also gives the prosecutor a chance to ask you questions. And so they might trip you up into saying something that makes you look guilty, even if you aren't. And so it's really important that the Constitution offers that protection. And then after a trial, even after a trial's over, whether someone is found innocent or guilty, there are more due process protections. One of those is you are protected against double jeopardy. You are protected against double jeopardy, which means you cannot be put on trial twice for the same crime. If you're found innocent, the police can't just wait outside the courtroom to arrest you and put you on trial again until a jury finds you guilty. And if someone's found guilty and they serve their time, then they can't be arrested and punished again. And for those who are found guilty, the Constitution protects them from cruel and unusual punishment. And then the last one I would talk about is the parole process, right? That prisoners have access to the parole process or the parole system. Parole is Parole. And so parole is, a process of going in front of a parole board who then looks at, your case and looks at your behavior in prison, and then is going to decide, whether you deserve to be released before your sentence is up or not. Right? That's in a nutshell kind of what the parole system is. And so prisoners aren't guaranteed parole by any means, but part of due process is having access to that parole system. All right, so last thing we're going to talk about here are just some disagreements about due process. Just kind of two sides to the argument that kind of broadly about due process protections and due process rights. One side of that is you have some people who feel that perhaps we have too many due process rights, that these become hurdles for the police to be able to do their job, and could potentially lead to criminals getting off on a technicality. I'll say that one again just because it doesn't mean people think that we shouldn't have any due process rights, but some people question whether maybe we have too many requirements for the police, things like that, right? Because maybe it creates all these hurdles that police officers have to remember to do this and do that and do this and do that. And they worry that criminals may be able to get away with their crimes simply because, a police officer forgot to do one thing or didn't read them that right or something like that. And they might get off on a technicality. The other side of that argument is that you have others who would argue that we need more due process rights, that they have to be better protected than they are. Because otherwise, someone who is innocent could get sent to jail. And we don't want an innocent person to go to jail simply because their rights weren't protected. And unfortunately, if you do a Google search, you'll find plenty of stories about people who spent time in prison, sometimes, decades, for a crime that they later on were found innocent of.